All right, back on the record for the purposes of convening a charge conference for considering the instructions to be given to the jury as well as the issues and recommendations as to punishment form. Let's start with the state and ask the state well, among other things, what aggravating circumstances the state is requesting, as well as if there are any other pattern instructions that you're requesting to be given to the jury.
Your Honor, thank you, sir. At this time, the state would be requesting that the aggravating circumstances that go to the jury would be E5, E6, and E9. E5, the committed while engaged in a robbery. E6, capital felony, was committed for pecuniary gain, and E9, capital felony, was especially heinous, atrocious, or cruel.
All right. Any other pattern instructions in non-substantive instructions that you're...
The only other issue of concern to us would be your ruling on Ronald Anthony's, the status of his plea and punishment. If we can address that whenever Your Honor wants to, but we do, in the event that you do allow some argument as to his plea and sentence, we do have a proposed limiting instruction on that.
All right. Well, we'll get to that, I imagine, through the defense. But and does the defense wish to be heard on any of these aggravating factors or circumstances? Excuse me.
We're planning to hand up some proposed instructions, and I know that it actually includes some language with official objections to both E5 and E9, to heinous, atrocious, and cruel, and to the use of the E5 one, based on 5th, 6th, 8th, and 14th Amendments. And I think we're planning to hand all of them up, but maybe we could find up those two, just because I know it has some language that I want to make sure that we have.
That's your copy?
That's my copy, but it's not the court copy.
Oh, you want me to hand them? Oh, Your Honor, may I approach?
Yes.
These were instructions, just because we have a couple of... But specifically, I am concerned about submitting to both E5 and the robbery aggravator and E6 pecuniary gain, in that I believe that they overlap as the type of evidence, and that there's some case law out there that shows that there are limited circumstances where you can go ahead and submit both of them, and I would say this would be not one of those cases that would allow for that, submitting both, that it's I think our courts have looked at it as a double jeopardy thing, can overlap and using the same evidence for the same aggravating circumstances. So I think there's a lot of concerns about that. I have a moment I can start studying some of the case law that says that.
Well, and let me call the state's attention and hear their position. So, and I'm looking at Jeff Welty's book, which I know we all have on our desk, page 173. So E5, so the felony murder theory was based on burglary. So the armed robbery is not problematic with respect to E5. But then the very first sentence on page 177, relationship between aggravating circumstance E5 and E6 is that both E5 and E6 may not be submitted if the motive for the felony supporting E5 is pecuniary gain. For example, if the defendant killed the victim during the course of a robbery in which the defendant sought the victim's money, and the defendant was convicted of first-degree murder based on both theory of premeditation, deliberation, and the theory of felony murder, trial judge may submit either E5 based on the robbery or E6, but not both. And then, so I mean, this isn't exactly the situation we have because the underlying felony was not, was burglary, not robbery, but it seems that that language is, at least that opinion of Mr. Welty is pretty broad, and he cites a case that we'll need to think about. So, Mr. Waller, what's your thought on that?
Our argument on this issue would be that there were two transactions, and I do have State of North Carolina versus Philip Antoine Davis, 353 NC1, and I apologize, I don't know what I was thinking. I didn't bring copies, but I do have a copy for the court if you would like me to.
I'm sorry, what was that citation? I'll just pull one up here, and you can give.
353 NC1.
All right.
And basically what that case would stand for, Your Honor, is if there are two different transactions involved in the robbery, that you can essentially break the items taken out. In this case, it was in the Davis case, it was a case out of Nashville, where the defendant took several items from the victims, and then that was the basis for the robbery, I think, such as taking a car and a VCR. And then to support the pecuniary gain, he also took credit cards that he went to a department store and used those credit cards to purchase items of clothing. What my argument to you in this case would be is that the robbery consisted of the iPhone, that was clearly taken during the course of the assault based on what we've seen, the testimony in terms of where the where the iPhone was by her head, there in her bed. Once the attack had finished, there's clear evidence that the defendant and his co-defendant went through the house, plundering through those boxes, through the armoire that we've seen, her purse. You've heard testimony about blood on the checkbooks and wallet there in that purse. And the property that we would use to support the second pecuniary gain would be the Victoria's Secret box and the iTunes card that was found out by the fence line, and that property would have been taken during the second phase of the attack. I fully understand that it was left there by the fence line for whatever reason, if it fell out or they discarded it once they saw that the bracelet was, not of great value. But what I would argue to you that there was a break in the action in terms of robbery for the iPhone. At that point, Melissa is killed, and then moving to plundering through the apartment to look for other items that they could be used for monetary gain. And I believe that is with the 21st assignment of error in the Davis case. And basically the holding that I'd be asking you to look at is both circumstances were supported by sufficient independent evidence of two transactions.
Will you hand me those DPS records? I can run anything out of here.
I'm having trouble distinguishing State versus Quisenberry, 319 NC 228, where the court said, although this was the case of first impression where a defendant was convicted on both theories of first-degree murder, and the court said, we conclude that one plainly comprises the other, although the pecuniary gain factor addresses motive specifically. The other cannot be perceived as conduct alone. For under the facts of this case, the motive of pecuniary gain provides the impetus for the robbery itself. Admittedly, situations are conceivable in which an armed robber murders motivated by some impulse other than pecuniary gain, where the robbery is committed to obtain something of purely reputational or sentimental rather than pecuniary value. But the facts of this case, though, reveal the defendant murdered the shopkeeper for the single purpose of pecuniary gain by means of committing an armed robbery. So I'm not sure how this case is complicated a little bit more because the underlying felony was burglary, but for both offenses, it seems that the motive can only be viewed as pecuniary gain. And that's, I think for the purposes of this analysis, we set aside the fact that the underlying felony was burglary, and we just focus on, is pecuniary gain the motive for an armed robbery? And if it is, then it's improper to give both aggravating factors. That would be my analysis.
And that's fine. We understand it. The independent transactions was kind of what we were looking for in this case. We understand that, and I will concede that if he had stolen a car afterwards to flee the scene, maybe we're even in a different ballpark.
Right.
But I agree with the court in that it is a close case. But I do think it's an issue that we felt needed to be addressed with the court, and if you're prepared to not allow one of those, we understand that position. But we would submit to you, there is a break in the action here in terms of, and it's clearly shown by the blood trail we've talked about earlier. She's been murdered, and then they stay in that house and do other things. So that would be our argument for allowing it.
Right. I think it is a close case, but I would find that they're redundant and would only allow one or the other, and presumably which E5 would be the one that you would. All right.
We would object to E5 for the reasons that we submitted in the.
Right. I'll read that and consider that, but I think that.
And Your Honor, I handed you two things, one pile or a set of documents related to requests with regards to the jury instructions, and then the separate single document are all of the proposed non-statutory mitigators, as well as a written request for the statutory mitigator that we're requesting.
All right, and I see here your objection to E5.
And I will acknowledge it's not case-specific and is submitted some standard arguments.
Right. The objection to the use of E5 on the basis of an armed robbery, and we'll give that instruction. All right. As far as E9 goes, I'm going to find that the evidence would support the giving of that instruction as well, so I'm going to overrule the objection to E9.
And I'll just put on the record, both the kids in the writing that we're objecting on the 5th, 6th, 8th, and 14th Amendment grounds, and specifically not cruel and unusual punishment, but also vagueness as part of our objection.
All right, those
No one should be heard
objections are
further.
overruled. All right, anything else? We'll get to the issue, I'm sure, at some point about the use of, the relevance of a co-defendant's sentence. We'll get to that, and I'll certainly hear from you at that time on that issue. All right, let's turn.
If we want to start out with list of mitigating circumstances, I will say that because we acknowledge it would be an issue. I think we put it as our first one, so we could just go ahead and after the first non-statutory one, so we knew that would be an issue, and it could be something for us to address with the court. If we want to go through the mitigating circumstances first, and then our special request for instructions after that, or however the court would.
Yes, I'd like to go through let's start with statutory, and then we'll move to non-statutory. And let me find, all right, so F7 is the only statutory mitigator that you're seeking.
It's the only one we're seeking. We do
All right.
realize
Yes, sir.
that
All right,
there may be other
and you're
ones.
seeking a peremptory instruction on that.
We are seeking a peremptory instruction.
All right, what's the state's position with respect to F7, age of the defendant, and the peremptory instruction?
Oh, we don't have a position on that, Judge.
All right. All right, I believe that would be one both appropriate to give that statutory mitigator and also to give the statutory peremptory instruction language with respect to that mitigating circumstance. And I've printed, in the draft instructions that I gave you, I printed the pattern suggested peremptory language that would be provided, so I would intend to follow that. Here, the language is a little bit out of order, but in any event, I'll follow the pattern language in 150.11 for peremptory instructions. All right, let's go down to the non-statutory. So the very first one is that Ronald Anthony is serving a life sentence for the same crime. Let me hear your arguments with respect to that in light of the case law that was cited by the defense.
I'm not going to belabor the point. We recognize that the North Carolina, I do want to get to the issue about whether we can discuss it and all in terms of the catch-all, but as far as submitting it, we do recognize the North Carolina Supreme Court has language against us submitting it. We would maintain that under the United States Supreme Court case of Parker v. Duggar, that they talk about the mitigating effect of a co-defendant's sentence in that case, and that we believe that under the Eighth Amendment and under Lockett v. Ohio and its progeny that we're entitled to instructions that we do recognize that the North Carolina Supreme Court has considered the Parker v. Duggar argument in the past and has rejected that argument, but we are still making an official request for that for purposes of review.
All right. I'm not going to give this as a non-statutory mitigating circumstance. I would decline that request. We'll talk about it again in the catch-all.
Okay.
I'm happy to talk about it now.
If the state's prepared to talk about it now, we can talk about it now, or we can talk about it later.
All right. Go ahead.
Go ahead and talk about it now.
Sure. Let's
Okay.
talk about it now.
I have a case up looking at it too, and I'll give the state side about it. The site that I would turn the court's attention is to State v. Roach, 358 NC 243, page 314 of the case. And what it says, it's just a couple of paragraphs starting on page 314 of it. It talks about basically that if a co-defendant sentence, the argument in Roach was they should have admitted the co-defendant sentence. That is rejected by the court, but then they cite two cases for when it comes in for other purposes and acknowledges, they say in Roseboro, we acknowledge that the jury may consider an accomplice's sentence as a mitigating sentence circumstance under the catch-all instruction. However, the consideration applies in a case where the evidence of the co-defendant's sentence is already before the court, such as where the co-defendant testified at trial and evidence of a plea bargain was presented by way of impeachment. We have a very similar situation, which is it was given for purposes of impeachment with it. It cites two cases that I think are also, both of them are relevant, both Roseboro and Gregory. My memory is that in Roseboro, the state, it was presented in evidence and the state argued about it and they said that was fine. In Gregory, they noted that the jury could consider as a catch-all mitigating circumstance since that evidence was before them. They declined the issue that it should have been submitted, but they noted that it was proper because the jury could have considered it anyway under the catch-all. And so we would argue in those cases that if it's before the jury's consideration, we would further argue that the state has already said that it should not be considered in its opening statement, and that is a reason that we should, under the Constitution, be able to rebut their argument about that.
All right. And what's the state's position on this?
Just a moment, Your Honor.
Yes.
Your Honor, sorry, what I was looking for is, I think Roseboro and Roach both stand for the proposition that this is not a mitigating factor that could be used under the F9 provision. In Roseboro, they did acknowledge that it could be considered at times under essentially what you have as F10. So I think there's a distinction there, between F9 and F10. I do not see any case law in which this is appropriate to list under F9, where I think the jury was going, where the court went was under 10.
They've already conceded that.
Okay.
Yeah,
And
they
so-
conceded that.
And so that's the issue that we're dealing with. I would, in this case, it's different than what was talked about in Roach, because in Roach, that person actually testified, and that plea bargain was in front of the court. Here you have the 806 argument that I'm sure did come up in the case in chief, but it's not the example, and there's nowhere in the case law that I could find in which an 806 impeachment has come into play. All the case law I found is you had somebody on the witness stand in which they admitted to a plea bargain being in place. So that would be my argument for why it should not come in.
I actually read Roseboro a little bit differently than perhaps both of you do. The way that I read Roseboro is that it would support an argument by the state that the jury should not consider the sentence of a co-defendant, but because the jury has this catch-all where they can consider anything. And I think the way I interpret Roseboro is that it's appropriate for the state to inform the jurors that that is not relevant to the case. And I think because Roseboro upheld the prosecution's argument, that's what that case was about, was an objection to the prosecutor arguing the lack of relevance of the co-defendant's statement. But I don't find any support for the defense using that or arguing that as a mitigating factor. That, it seems to me, is clearly laid out in black letter law that it is not relevant and not a mitigating factor.
Well, again, I would both look at, you may have already done that, but both Gregory and in the whole context of Roach, and they said in Roseboro, we acknowledge the jury may consider, and this is a case where the defense is making the argument, hey, we should be able to get in that mitigating circumstance, and they're saying basically in Roach, you had a point if it had come into evidence, but it did not come into evidence, and therefore you lose. And with it, and so they do cite Roseboro for it, but they said in Roseboro we can now, so it's basically they're taking the state's point and they're not saying, well, that's only something the state can argue. They're saying that the jury may consider an accomplice's, the quote, exact quote, the jury may consider an accomplice mitigating in the catch-all instruction.
Slow down.
I'm sorry. However, this consideration applies in a case where it's only such and such. And so therefore, it is a case where the defense is trying to get it in, and they say why it's not justified there under Roach. So that is at least the North Carolina Supreme Court's interpretation of it. And it also, again, point the court's attention to Gregory. I do understand what the court is saying about Roseboro, and that was the argument in Roseboro. But I do think that in it for both Gregory and Roach, when taken in combination of Roseboro, does stand for the proposition that we are allowed to argue it as a catch-all if not have it submitted.
I don't believe that that overrules the black letter law, that it is neither, that it is not relevant as a mitigator. And so I would the Supreme Court has repeatedly held that a co-defendant's sentence for the same murder is irrelevant in a sentencing proceeding. So I fail to see how that phrase changes it. Again, I continue to read. I understand your argument, and the court's in dicta, I would say, may not be saying the same thing, but the way that I read the Roseboro case is that that the jury may consider any circumstance means that the jury has very broad instructions with respect to what they can consider, and to not permit an argument that reminds the jury to consider only those things that are admissible and relevant to the proceedings, that is an appropriate argument for the state to make. And it would be akin to saying you should not be swayed by sympathy, for example, that sympathy is not relevant to this proceeding. But the state is entitled to say that, to remind the jury that it's bound by the evidence in the case. And so that's how I would interpret the Roseboro case, and I do not see the Gregory case as overruling the black letter law that a co-defendant sentence is not relevant in the sentencing proceedings. So I would decline to give it as a specific mitigating circumstance, and I would also rule that any argument that suggests it should be viewed as a mitigating circumstance would be inappropriate.
Both things, just for record purposes. Well, one for clarification purposes and one for record purposes. For record purposes, it would be our intention, we're not going to violate the court's order to do a proffer, but it would be our intention, if the court had not forbidden us, to make that argument that it should be done under the catch-all mitigating circumstances. We will not do that. We do think that it is certainly, and I don't believe this is the court's order, but I do want to make sure, for us prohibiting us from making relative culpability arguments in closing.
Well, you mean just simply
Talking about who is
right? Who
that
was
he's not
the leader? Who was the follower?
Who was the worst of the worst type of person? Is the right type of things.
Right. I think that those arguments are different.
Yeah.
Species of arguments. So I think those are not within the scope of the order of the ruling I just made. All right, let's go on. All right, we have a series of, going back to your list, we have a series of mitigating circumstances, non-statutory. Travion's mother was homeless while pregnant with Travion. Travion's mother did not provide basic care for Travion when he was a baby. Travion's mother used alcohol, cocaine, and marijuana while she was pregnant with Travion. I'm going to skip number 5 for a moment. Number 6 is Travion's mother used drugs and alcohol when Travion was a baby and a toddler. Number 7 is, and remind me, the Harsnip court was the mother's residence, right? So Travion's neighbors at Harsnip court noticed he was hungry and noted there was no food or formula in the house. Travion's mother put alcohol in his baby bottle to put him to sleep. What I would be inclined to do is, and of course we'll hear from the state on these, but I would be inclined to allow non-statutory mitigating circumstances, but in a more consolidated form, rather than, I don't know, 8 or 10 that I just read as individual ones. consolidate them into one or perhaps two.
Your Honor, I would say that we have done more consolidation. It may not seem that way, but than is the usual practice for it, and the usual practice is to get out different facts with it and all, and be able to state those particular facts and let the jury decide whether to give them weight and mitigation with them and all. And I think it's a concern that we try to consolidate it, both in losing the power of it and everything else. So I don't think, we don't have a case here where we're submitting 200, we're submitting 37. And so we would object to, we understand there may be some consolidating, but I certainly think taking this and consolidating this into one or two would be not only against what the practice has been, I think, throughout the state, but also against the emphasis about being able to present anything as mitigating for it.
Does the state have a position on?
I mean, that was my initial reaction, is a lot of these things seem to say the same thing, that he had a bad childhood. But I guess out of an abundance of caution, that if they want to do it this one sentence way, then we would not be opposed to either remedy.
All right, I'll give them as requested in terms of isolating facts, if that's the way that the defense prefers them. What's the state's position? Let's go down the list then. So Travion's mother was homeless while pregnant with Travion. What's the state's position on a peremptory instruction with respect to that mitigating circumstance?
She was home. Just trying to remember. I'm trying to remember the evidence. That's right. Your Honor, I was just trying to remember the facts as they came out.
All right.
I think there is evidence she was at a shelter.
All right. Number 3 is Travion's mother did not provide basic care for Travion when he was a baby. I'm inclined to provide or to allow that mitigating circumstance to be given. What's the state's position on a peremptory?
No position.
I'll allow a peremptory on that as well. Number 4 is Travion's mother used alcohol, cocaine, marijuana when she was pregnant with Travion. I will allow that. I'll have to rely on, I don't recall that specific testimony at trial, but I'll certainly rely on.
She testified that she had substance abuse problems with those items, and Quentin Bullock gave testimony about that behavior being constant, that there not being any time period in which it was not true. That's my recollection, and I would certainly, but that's my memory.
Right. I do certainly recall that. I just don't recall a specific question or answer about did you use cocaine while you were pregnant with Mr. Smith. So I don't recall that specific line of questions. But
And he did say that, Quentin Bullock did say that when he had to go rescue her, the most specific memory he had of that was from a place that he specifically said was a crack house. Right. And that then she had not wanted to leave once they got there, and she had wanted to stay. And she testified to that being one of the substances for which she needed treatment.
Right. And in the chronology of things, was she pregnant at the time that he went to pick her up?
Honestly, Your Honor, I don't think that was specific to that time. My memory was that their earlier concerns were when only Aaron was there, and that he was describing the same behavior. And so I was basically asking were there any periods where this was not the pattern, and he said no.
All right. I would leave evidence on that then in the province of the jury. There's certainly evidence from which they could infer that, but in terms of a peremptory instruction, I think that's for the jury to recollect. Does the state have a...
We would object on that.
All right, so I'll provide that instruction, but without a peremptory. Number 5 is Michael Clark did not want Travion to be born, as evidenced by his beating and punching Antoinette Smith in the stomach when he learned she was pregnant. I'm inclined to provide that instruction. State wish to be heard with respect to peremptory. You object to that?
I think if we heard Michael Clark testify, then that could be an issue, but we haven't heard from him.
I don't believe there's any evidence that controverts that impression that Miss Smith had, and her testimony about what was said during that encounter. So with no contradictory evidence to that, I'm going to allow the peremptory, or I'll give the peremptory on that one. Trevion's mother used drugs and alcohol when Travion was a baby and a toddler. I'm inclined to give that instruction. State have a position on the peremptory? All right, I'll allow the peremptory on that as well. Number 7 is Travion's neighbors at Harsnip Court noticed he was hungry and noted there was no food and formula in the house. I'm inclined to give that instruction. State have a position on the peremptory?
No, sir.
All right, I'll allow that peremptory. Trevion's mother put alcohol in his baby bottle to put him to sleep. I'm inclined to give that instruction. State have a position?
The testimony, even in their own expert, was that from the CPS records that they witnessed other people doing it rather than his mother, but I'll leave that up to you.
CPS records do make reference to the men that were around the apartment doing it. Claudia Janes testified that it was something that she saw Miss now Yarborough do. So there were the references to it were separate in the two different places.
Peremptory instruction on that as well. Trevion's father resented having to raise Travion. I'm inclined to allow the circumstance. Does the state have a position with respect to peremptory?
Yes, we would object.
All right. That one, I believe there is certainly having to raise Travion is a very broad span of time. I mean, maybe that he resented having a 2-year-old brought to him or brought to his house, but to say that he resented it as a categorical statement, I think I would let the jury determine whether that is the case. Number 10, Travion wanted a stable home life and loving family as evidenced by his desire to live with his maternal grandmother or Candy Albrecht. I'd be inclined to give the peremptory. State wish to be heard with respect to the peremptory.
Object on that one. I don't know that we have any evidence of wanting to live with his maternal grandmother. And the statement to Candy Albright was that he loved her. But I mean, I think there's also contradictory evidence that Travion had a home to go to and that he disobeyed rules and was kicked out of that house because he couldn't abide by rules as well. So there's contradictory evidence there.
All right.
Your Honor, my recollection is that, and I certainly recognize that my memory is not always right because I've talked to a lot of these witnesses at other times as well, but that Corey Smith did talk about the fact that that Travion would want to stay at his grandmother's house when he was there, but it's possible that that didn't come in. And so that's who my memory would be of giving that. And then Candy Albrecht, I think everybody remembers the content of that exchange and the fact that Travion would ask her if he could stay.
All right. I don't recall the maternal grandmother discussion. I would leave that as I would agree that there is, again, first of all, it's a very broad period of time we're talking about, and so categorically to say that at all times in his childhood he wanted this, I would say that as a peremptory that'd be inappropriate.
We wouldn't object if the court wants to just take it off the list. I mean,
No.
or the part, I'm sorry, I misspoke, the part with the maternal grandmother.
Right.
So remove her from the instruction entirely.
That's what I was going to suggest, is that I think the fact that he wanted a stable home life and loving family is And you can certainly argue the evidence, but I'm not opposed to leaving it as evidence by his desire to live with Candy Albrecht. That would be fine as well, but I would decline to give a peremptory instruction on that.
And so that would be our desire, just to remove the reference to his maternal grandmother, so as evidenced by his desire to live with Candy Albrecht.
Yes, that's fine. Travion has a history of mental illness. I'm inclined to allow that as a circumstance to be given. What's the state's position with respect to peremptory on that?
We would object on the peremptory on that one.
Speculation.
Yeah, there's been no doctor to testify as to a mental illness. At best, we have people saying that he came to this program because of a mental illness, but it appears that the mental illness that they were talking about were fights in school. So I would object. We haven't heard from anyone qualified to render an expert opinion on that.
What is the definition of a mental illness, and would that include things like ADHD?
We also, Dr. Evans talked about several different types of mental illness that he had been diagnosed with previously.
Right, I was going to actually refer to that report.
I know that ADHD is in there, as is oppositional defiant disorder and depressive disorder not otherwise specified, is my recollection of the 3 prior diagnoses that he had at the time that she was reviewing his prior records.
And I guess I can wait till you're done looking, but the issue is she said that at some time in the past he had been diagnosed with that, and so to say he has a history of mental illness, she reviewed some records, but there was no diagnosis that anyone in this courtroom gave in terms of that. Certainly can submit that that's something they should be able to argue, but it should not be the subject of a peremptory instruction. It's our position, and has been, that they were trying to backdoor that in through different witnesses, but no one here came in here definitively and said, I have diagnosed him with this, or he has a history dating back to such and such. She was allowed to rely on it. Thus, I would say it's not warrant a peremptory.
Be comfortable with this one. I mean, I believe that the closest that there is to a diagnosis is Dr. Evans, where she recounts in her report that he has been diagnosed of having ADHD, oppositional defiant disorder, and depressive disorder, NOS, which is what, non-specific or something?
Not otherwise specified.
Not otherwise specified. I would be more comfortable with this to, rather than simply use the broad term mental illness, to say that he had received these diagnoses and also include language about that he was treated at day residential, outpatient, and various clinical facilities, or some language that encompasses the list that I was looking for a few minutes ago that you handed up to me yesterday, Ms. D, I believe, that itemized a number of different.
They don't have that information, though, Your Honor.
Well,
So-
they do. They certainly have information that he was treated at Holly Hill, which is residential, at Wright,
Yeah.
which is a residential educational,
Right.
at a day
Treatment.
facility.
I just wanted to make sure I was clear, and I know that the state would have made sure the court was aware of the same thing. There are a number of treatment providers on that list about whom the jury has heard nothing, so that they're not the Venn diagram has lots of parts that aren't connected.
Right. But I think what I'm inclined to say is I think that there is no dispute to the evidence. The way it stands right now, I think, in one sense, he has a history.
Maybe we could track, I mean, I believe Dr. Evans talked about specifically what was in her report about all those things, so we could track, if we wanted to do that, those places. I don't believe, correct me if I'm wrong, there were other places that there was evidence at least about him going to long-term or residential treatments post her report, so we could put in evidence about that report. Is that, with that, so we could put down what she testified, because we know that she testified to those specific things.
And I'm not even suggesting that be by name, although that might be as good a way of doing it, but rather by characterization of that. I know the evidence. I mean, there was evidence about, are you aware that he was at Holly Hill? Well, what's Holly Hill? It's a residential. And he was at Wright School, and what's Wright School? It's, so I think that if it's characterized, if you want to give the list, I think that is uncontroverted. That this report, I think, is uncontroverted evidence that at some point he received in his lifetime he received these specific diagnosis, and it's also uncontroverted that at various times in his life he was treated at various types of either educational facilities or mental health facilities, and those are all in evidence, and there's no controversy as to that. And so if that's acceptable, I think that would be one that I would give, but I'm just concerned that it be a bit more specific rather than just simply say it's a history of mental health. That to me invites some speculation and.
Would you like us to redraft a version of that and just resubmit it between now and Monday?
Right. Right.
And it would be appropriate for us to email you and the state, so we can come Monday and obviously put it on the record at that point, but that way we would have, both sides would have some idea what we'll be talking about for closings.
Yeah, I want to be cautious that everything we do in this case is on the record, but as we did last time, over the weekend, it certainly, to the extent that you offered to submit additional authority on an issue, and I was able to take that into account, and then when we got back on the record, discuss that in a way that we all knew what that authority was. I think that that's an appropriate way of proceeding. So I'm not going to, everything we do about discussions about it, back and forth, my views on what you've submitted, those sorts of things we'll do on the record. But if you want to submit a proposed instruction to me by email, then I'll certainly have that and may well include it in the next draft so that we have a clean draft that we can work from when we get here Monday morning. Does that sound like something that everyone agrees is consistent with law? I want to be very cautious about having out-of-court dialogue.
Essentially, it's submitting briefs. I mean, if we look at it in that way.
Yeah, I mean, I think it's very, I think it is required that every email that involves you, Your Honor, has to be made part of the record with it and all. I mean, obviously, emails between the state and us doesn't necessarily have to be unless it's forwarded upon you, but I think everything else is long, and it's my understanding that you have taken the emails that we've done, printed it, and then we've recreated the discussions on the record the next day.
Right.
So I think as long as we do it that way, I think that's appropriate. And so I just was thinking that, we may end up with a couple other things, but that may be that. It's also possible, I mean, it's our goal to have every mitigating circumstance today. It is, possible that I'll wake up in the middle of the night Saturday and say, oh my goodness, I forgot this.
And that's fine. So, yes, let's continue that way. The line I drew in your emails is I certainly was pleased to receive them, but I think I responded back to both of you for reasons that we'll talk about on the record.
Yes.
Thank you, and we'll discuss these on the record, and I'm not going to engage in a dialogue with you. I agree with this, or I'd like you to change this word, but it would certainly be helpful for you to submit your proposed language to me by email, so that when we get back in court, I'll have a complete document, and then we can discuss the propriety of those instructions as we go forward. All right. Any concerns? All right, very good. All right, so yes, if you'll, so on that one, I would be inclined to give a peremptory instruction, or peremptory instruction on a mitigating circumstance relating to mental illness, but I would like it to be as specific as possible as to the mental illness that you contend the record supports, and I would also suggest that there be some identification of the type of treatment that was provided over the course of the lifetime. All right, number 12, Travion experienced physical, emotional, and verbal abuse by his father. I believe that is supported by the evidence. Does the state wish to be heard with respect to the peremptory?
In your discretion.
All right, I'll allow a peremptory on that. Travion grew up in a chaotic and volatile home environment. Again, I think the evidence would support the giving of that circumstance. State wish to be heard on the peremptory.
Yes, sir.
All right, that one I'll provide a peremptory as well. Earl Dean Bailey and other family members attempted to foster relationships between Travion and his brothers when he was a child, but Michael Clark did not support those efforts. Support that. What's the state's view on?
The last part about Michael Clark did not support those efforts. I know there's one of the brothers testified at one point that the father did bring Travion up to Franklinton, so we would object on those grounds.
And there was
Then they went on vacation together, so.
Your Honor, regardless of whether a peremptory would be appropriate or not, it was clearly Earl Dean's testimony that the grandparents who felt like they could not take on the two additional youngest children were very open and worked very closely with her to make sure that Aaron, her grandson, had an ongoing and regular relationship with those two older brothers, and that Earl Dean would reach out to Mr. Clark, but had trouble getting him to sort of participate in that effort to keep all the brothers connected. And she talked about the relationship that she had and still has with the Smiths, and I don't think that there's any evidence that any sort of similar relationship existed between Michael Clark and the Smiths. And all of the evidence was that Aaron had a far more regular and a far more sort of sustained relationship with his older brothers.
And I certainly agree that the evidence supports the giving of this mitigating circumstance. I think Mr. Waller is correct that there's certainly some instances where other family, his brothers, there was some cooperative relationship. So to categorically say he did not support this, I think is where I'm resisting giving a peremptory instruction. Would leave that in the discretion of the jury. But I certainly think there's evidence that would support the giving of this factor or circumstance. Wake County Department of Social Services failed to protect Travion.
We would object to both.
All right.
I think that's there's plenty of evidence that Department of Social Services did a lot to help Travion Smith.
Let's hear what you have to say about this.
Well, Your Honor, I think that, Dan Bierman said that in many aspects they did do a very good job of helping with concrete items, particularly early on in their involvement with, so basically the first time abuse or neglect was substantiated was the time that the call was made because of Aaron having the burns in the black eye. And then that case closed, and then another case reopened shortly thereafter, and that report was also substantiated. And so, and it's after that report that was when they were in the apartment together at Hair Snipe, and the conditions were so bad inside the apartment, sort of that there starts to be a change. But after that initial report with Aaron, they helped him find housing, and they did all of those concrete things that no one's disputing. But after Travion was in the picture, there's the time period where it's like 18 months before the notes are even dictated. And there are a lot of recommendations made for things that Antoinette should do, but none of them are followed up on. And our larger argument with that is just that there was not ever really any sort of cohesion to how the whole case was looked at. I think the fact that Miss Cannon, who you can tell from the records is just a neighbor of Miss Smith's out in the public housing development, some years later is being identified as an aunt and has been given custody of this baby with absolutely no sort of kinship placement evaluation, is significant. And I think that from that, the jury could ascertain that they did fail to protect him. They may not find that that is present. But I think that particularly in light of the fact that at least one of the CPS reports mentions the fact that Lori Cannon, that surrogate parent who we know had him for some period of time, was also beating him in a way that other neighbors thought was inappropriate, and that's never followed up on by the Department of Social Services. They sort of never connect those dots and see that it's the same person with the same name and the same address who's being referred to in the reports. And then let that kinship placement occur is another thing from which the jury could conclude that there weren't all the most appropriate efforts being taken to protect him. And I also think that, again, the fact that one of the initial reports about Aaron did have to do with cigarette burns and a black eye, even though they substantiated for neglect at that time because they weren't able to really ascertain what had happened, so they could not make any proof on the fact that the mother was responsible for the injuries. the fact that there are then these other reports, even if they're crossed out and the supervisors come in and put their initials on it that have to do with burns on Travion, I think that there are things in there from which a jury might conclude that, or they might not.
And Judge, their expert's opinion, in summary, Wake County DSS provided some important concrete services in the second CPS investigation and follow-up. Crucial services that could have increased the capacity of Antoinette to provide safety and nurture to her children were recommended but never offered. That's his opinion, not that he never once said that they failed to protect Travion, so that would be my objection, that his own opinion is not that strong. And that was their one expert they called.
Back at what his specific answers were to the questions in court. But again, Your Honor, I think that that is something that the jury could reach a conclusion about. We could redraft that. I believe that what he said a number of times on the stand was the Wake County Department of Social Services missed opportunities or failed to develop a meaningful relationship with Miss Smith. So we could, which would have made more robust intervention possible. I mean, we could redraft it in a way that is more in line with some of the specific conclusions he reached here. But that was, those things that I outlined before are some of the evidence that's before the jury from which we think they could reach this conclusion.
The efforts of Wake County Department of Social Services were not adequate to protect Travion.
You would be very happy with that.
And
We would still object to that. That's, Travion was involved with Department of Social Services, fine, and let the jury decide whether or not they failed him. But
Your Honor, this is one where we were attempting to do something shorter. I mean, we'd be happy to break it up into something, two separate things, such as the Child Protective Service reports against Travion Smith's mother were substantiated twice during the time she was pregnant with him and the time that she lost custody of him. That could be one. And then a second one could be the Wake County Department of Social Services failed to conduct any kinship placement analysis before allowing Travion Smith.
This is the last few things I have to say.
And also looking to what his actual testimony was in court, Mr. Brown was taking notes, and what Mr. Bierman said in court was they did not meet the standard of care for Travion. So, I mean, we could break it up into, we could use standard of care in here, we could break it up another way.
the language that I just said, I think I would give that as a mitigating circumstances that the efforts of the Wake County Department of Social Services did not adequately protect Travion. Leave that and then let the jury figure out. Let the jury weigh the evidence on that issue. Travion earned the Pruitt Award while attending Wright School. This award is given to students who never received a timeout, never had to be restrained. I'm inclined to give that. The state wish to be heard as to the peremptory?
that's fine.
All right, so Travion responded positively to praise and attention from his teachers and mental health workers. I think there's certainly evidence that supports that mitigator. State wish to be heard with respect to the peremptory.
As there's evidence that he was also disrespectful to teachers and other workers.
There's certainly instances that were testified to. I think if the word often or often responded, something to that effect, it would be uncontroverted, but again, perhaps the categorical, unqualified statement. Sorry.
I mean, whatever the court...
We would move to amend to include the word often.
All right. Yeah. Travion was enrolled in special education. That evidence supports that. Any objection to the peremptory? All right. Travion was recommended for long-term residential treatment, which he never received. Long-term residential, and does the Wright School not qualify as long-term residential?
Well, they come home on the weekends, Your Honor, so it's not. Wilderness Camp is the only actual, like, long-term residential placement that he ever got the funding for, got approved for, got placed in, and his father pulled him out after, I believe, 2 weeks. So the Wright School, he was basically went to Wilderness Camp very soon after his time at the Wright School, because the Wright School was involved in trying to, find a long-term plan that would meet his treatment needs. And so that's the placement that was settled upon. I think he went to Seven Springs, but he only stayed for a few weeks.
What's the state's position?
I mean, there's kind of an evidentiary issue with this one is we don't know what happened after X day, the last date that's been testified. But I mean, to say that he didn't receive the treatment is not true. I would think this jury would think that spending a week in this program would be long-term for 6 months. And then he received or he went to the wilderness camp, but he was pulled out of it. So he did receive some treatment. So. And we just don't know what happened after he was, whatever it was, 12 years old anyhow, because we don't have those records.
They both Dr. Blackshear and Dr. Evans.
I'm sorry.
Oh.
What'd you say?
Oh, I believe evidence about him not getting the proper treatment, proper long-term treatment afterwards was testified by both Dr. Blackshear and Dr. Evans.
If it was qualified by an age, namely when for example, when Dr. Blackshear was interacting with Mr. Smith, if you said, for example, and I don't know the specific age, but at age 12, Travion was recommended for long-term residential treatment, which he did not receive.
Yeah, I would have to look it up, Your Honor. I mean, I I would have to pull out a timeline. I know that that's when he was, there were different agencies that had contracts with Wake County Mental Health, and I don't remember, my memory is that the Dr. Blackshear was contracted not through Dominion Healthcare, which I know was one of them, but through, what was the other one?
It was therapeutic.
Strategies. So it would just be a matter of looking to, we have all kinds of, actually the one that you have, Your Honor, the one that the state handed up to you the other day?
It's not on there.
Therapeutic Strategies is not on there?
No.
Okay.
He
Because-
specifically said he was 12 or 13, and I asked him where he was in school, and he said Aversboro, and so then he said maybe it was earlier, so that's the problem.
Yeah, I mean, we didn't have the easiest time always recreating all of these records ourselves because the agencies don't exist anymore. So I wouldn't be comfortable giving an exact age.
Right. Yeah, I do have in my notes that Dr. Blackshear said 12 or 13 years old, and I recall that testimony about establishing what school he was in.
I think that was a similar age. Dr. Evans talked about him not getting, I think she said she saw him, I think 13 years, 11 months. Was when the report, my memory is when the report said was evaluated.
Well,
If that, I apologize if that's wrong.
again, I mean, this sort of categorical, and I agree with Mr. Waller, there are gaps in the history. We don't know what treatment was received after 2006. So some qualifier, I mean, I think that it's uncontroverted that at times recommendations were made that he received certain type of care that, for one reason or another, he did not receive. And so maybe simply saying at times, defendant was recommended to receive long-term care, which he did not receive, or mental health. Right.
So we have several that are coming up that I think if this one were just to read, at times Travion was recommended for types of treatment which he did not receive. I think that would be redundant for the ones that are coming up. The point of this one was the issue of long-term residential that is recommended in the Right School Report, was mentioned by Dr. Blackshear, and is also mentioned by Anne Marie Evans, and the fact that that was sort of this ongoing recommendation for years that was never addressed. So if Your Honor's not comfortable because of the gaps in the record and the gaps in the evidence, I'm not sure what number 19 would add if it just sort of says for types of care that he did not receive. And Mr. Brown may have a slightly different view from me, but that's my view on that.
Well, I guess I was trying to understand that what the suggested change was simply at times Travion was recommended for long-term residential treatment, which he never received. Is that what you're thinking of changing it? I think Ms. D may have been concerned about taking out the words long-term residential treatment.
Right. Well,
And clearly,
I think it's uncontroverted that Dr. Blackshear said, I recommended that he be put in long-term residential that has certain capabilities, and the father said, we can't afford it.
Yeah.
And so that's uncontroverted. And I would give a peremptory instruction on that there was that recommendation and that it was not done. But I guess I'm having two problems. One is the gap in evidence. We don't know what happened after 2006, so to say he never was placed in, I don't know. There's not evidence of that. But the other is I'm still struggling with whether the Wright School is a long-term residential facility, and, whether wilderness camp, I mean, he was placed in it, but he wasn't allowed to complete it. I mean, so I guess I'm struggling a little bit with the categorical statement that he was never placed in a long-term residential facility, when the jurors might say, well, yes, he was.
Would Your Honor be comfortable with Dr. Blackshear, when, recommended a long-term residential treatment for Travion Smith, and at that time, that treatment was not provided?
I think that is undisputed.
I think Dr. Evans did similarly to the same thing. I think she testified to that. She made the recommendations. She certainly made recommendations to treatment programs that she said were never followed through with or never done.
My recollection was that they could not find a proper placement for him, but that she didn't agree.
Maybe why it was not done, and I don't dispute, I think that's a correct assessment by Ms. Shikita, but what happened was it was never done.
Right, so, right, so either way, you can be specific and say Dr. Blackshear, and, I mean, I'm not sure Dr. Evans is in a position to make recommendations about his treatment. She's evaluating him, whether she says ideally this treatment would take place in a residential setting, whether that constitutes a recommendation or an observation and evaluation. I don't know. Her recommendations, that's not under the recommendations portion of her IEP evaluation. Her recommendations are that the IEP team meet, and that decisions regarding mental health needs and services be made by his father and the manager, and we can be of resources. So I think, again, it can be general to say at times it was a recommendation of long-term treatment, or that was not received. And then you can argue, I think there's certainly one instance of that, and you can argue there's more instances of that. That's fine. So are you comfortable with that language at times?
Just adding the only
At
change.
times, Travion was recommended for long-term residential treatment, which was not received.
Right.
I'm comfortable with that.
And the state wish to be heard further?
No, sir.
All right. Okay, so I'll give a peremptory instruction on that. Michael Clark did not have the parenting skills to nurture Travion. There was certainly evidence of lack of parenting skills. What's the state's position on that?
It's just such a broad statement. I mean, you got to listen to what the probation officer said today, that he was doing things to help him, that he had his best interest at heart. So, I mean, but I know that the coach said that he needed parenting skills. I realize that, but there's certainly evidence the other way as well. It's the broad nature of the statement is a concern to the state.
Yeah, my only thoughts on this is that, I mean, just based on the school and mental health records, it really would take extraordinary parental skills, facing some of the challenges that were presented. And that, so to say that, he lacked, I mean, I think the coach certainly recognized that there were additional skills that were needed, I'm not sure that categorically you can say that Michael Clark. Well,
I mean, I think, I don't mean to sort of have way much to say about these, but I think part of why, because I wrote that, and, you know, I think part of the point was that Travion did have a lot of issues, and Mr. Clark, I mean, you know, and for what it's worth, you know, the reason he didn't testify was because he got a doctor's note and told us that he couldn't. So we had thought he was going to up until the very right before trial. So, you know, he had a lot of his own limitations, and so it was sort of a combination of those two. Michael Clark and Dr. Clark did not have the kinds of skills that Travion Smith is. And that's sort of the intention of why I wrote it the way I did. But we are happy with whatever the court thinks is appropriate with all.
All right, what did you just suggest a few minutes ago, the language?
Michael Clark had limited parenting skills.
What's the state's?
It's sort of the opposite is to nurture Travion. Is it to nurture him, to handle him, to...
Yeah. Yeah, the word nurture, I mean, it's
my concern.
right.
Because there has been a lot of evidence that he came to meetings, he was present, he took him where he needed to take him. And so to say that he had limited skills, I don't think there's evidence of that, other than the coach said, and my recollection was that he essentially was in over his head, not that he didn't love him, but they couldn't do it.
Right.
And so that's why the way it's phrased is
Right, and I think there's evidence to support this. I would decline to give a peremptory instruction on this one. So we can leave it as it is, just with no peremptory. Travion is immature for his age. Again, there was evidence to support this, whether that could categorically be, I think that the evidence that supported that stopped it in year 2006. I'm not sure that any witness since then has said that, so I don't know if we can comment on maturity now. Or at any.
I would argue that the records from the jail are this that we've heard today are some evidence of his continued immaturity. So I think that there's plenty of evidence of that up until 2015.
All right, there's sufficient evidence to give the mitigating, but as far as a peremptory, I would decline to give the peremptory. Travion lacked basic skills for personal grooming and hygiene. Again, there was evidence of that at an earlier stages of his life, whether that's true, later stages.
We don't object. The court does not feel like that's an appropriate one for a peremptory, but we certainly think there's evidence of that.
All right, and then that's state wish to be heard with respect to giving of that. All right, I'll give that instruction without a peremptory. Mental health services would end abruptly for Travion as a child. Again, there's evidence to support that. As a categorical statement, I would say that there are instances where it's not true.
He completed the right school, it sounded like, so.
Right. So, again, is this one you're seeking a peremptory? I mean, I think that it, as a general statement, it's certainly true, and you can argue it, but to say it's true in all cases, I think.
We would not object to there being no peremptory with regards to that.
The nature of Travion's mental health and emotional problems required a stable, structured environment in order for him to be successful. There's certainly evidence of that. My impression on that is that would be something that the jury, it's in the province of the jury to decide what's necessary for success, and that That's a whole multitude of factors. So I would be inclined to give that mitigating circumstance without a peremptory. Does the state wish to be heard on that?
Yeah, and that was my issue about required, and I think that's what the jury needs to determine. It certainly was recommended as such.
All right. Michael Clark removed Travion from programs where Travion was successful. Again, there's evidence that that happened on some occasions, perhaps didn't happen on other occasions. So I would be inclined to give it as a mitigating circumstance, but as worded, I think it's would not support a peremptory.
We are happy for there to be no peremptory. We're also happy for both 25 and 26 to be changed from some programs where he was successful and from some treatment programs that have been recommended. But either way, we're happy.
All right. Treatment providers. All right. Yeah, and both of these are right. As they're written, I would certainly say there's evidence to support them, would give them mitigating circumstance, but as they're written, I would not give a peremptory. Does the state wish to be heard on either of 20?
As long as we're not peremptory.
Right. And I think you understand my general concern about these categorical type statements. If you want to take a pass at writing something that is more specific, then we can reconsider it. But number 27, Michael Clark removed Travion from Wilderness Camp, the residential treatment option that was secured following the right program after only a few weeks. I think it is uncontroverted that he did remove him, and this doesn't specify as to the reason. I think the reason for that, could be debated, but as it stands, I think this is uncontroverted in the evidence. State wish to be heard?
No, sir.
All right, so I would give this mitigator as well as a peremptory instruction on that. Turnover in mental health agencies led to Travion losing treatment providers.
Wanted to modify it to say to losing some treatment providers. Right. I think that would be uncontroverted.
What's the state's position on that?
As written, I think it's a very broad generalization. But some, I think, would clear that up.
Right. I think some would be, if the word some, losing some treatment providers, then that would be be given a peremptory instruction. So is that what you want to do? You want to add the word some? All right. Travion suffered from nightmares and night terrors as a child. I think the evidence supports that. The state have a position on that? Yes, sir. All right, so I'd give that with peremptory. People who love Travion value their relationship with him. There's evidence to support that. State. All right, I'll give that as a peremptory. Laura Cannon, surrogate mother, was murdered on June 8 when Travion was 5 years old. I believe that's the stipulation. Is that
murder? When she was murdered was.
Is that his age? I mean,
She was born on December 6th, 1992.
all right.
No, yeah, later that year, but he was 5 at the time.
Okay. I'd give a peremptory.
And I'll also note that I don't have certain
Surrogate
cases,
mother.
that since it was stipulated to, there may be some law, I think State v. Flippin, that may suggest that it would be a different type of peremptory because the jury cannot reject the fact it's been stipulated between the parties.
All right.
And
I will look at that issue. Did the stipulation also use the word surrogate mother?
And that was the state's objection to this one.
Well, we
I don't
didn't.
know that there was ever anybody said that she was a surrogate mother. I think that she took him in and they took care of him. But that's a very broad statement as well.
Well, we struggled with what to call her. There were so many names in the case, and so Laura Cannon,
The neighbor who cared for Travion.
yeah, but she wasn't just the neighbor because she leaves Hairsnipe, and so by the time she's listed as the custodian, she's at Bloodworth. So by the time her relationship with Travion transcended her neighborness to Antoinette because she's at Bloodworth with Travion, and Antoinette is wherever Antoinette is.
Is she listed in DSS records as a custodian?
She's listed as, so once you get to those later reports, she's the placement in DSS, and at that point she's listed as his paternal aunt, which she was not. She never was. She has no relationship to Michael Clark, but that's how she's listed in the records. And as such, she's listed essentially as his kinship placement. So they have Earl Dean Bailey then tracking out with Aaron, and they have Travion tracking out with Laura Cannon. But she was just, Antoinette's neighbor from back at Hairsnipe. So I think, and we could just leave it at, those are the facts as I understand the records to get there.
I would just say her name is sufficient in that, and they can explain who Laura Cannon is.
Right.
Travion's caregiver?
Caregiver?
That's fine.
Yeah.
Caregiver. All right, so with that change, from surrogate mother to caregiver, I'd give a peremptory instruction on that. And I will look up,
There's two state v. Flippins. First, state v. Flippin, Samuel Flippin, that talks about that issue, and
all right, I will.
I can't find where Mr. Welty's book is that I just was.
Oh, I'm sorry. I'm hiding Mr. Welty's book.
Okay. $689. All right, thank you. All right. Travion's mother would go for years without seeing Travion when he was growing up.
We just can't remember the year standard. I know the brother, at least one of the brothers said yes, it would be years, but.
And so did she.
That's my recollection. I'll give a peremptory instruction on that as well. Travion's mother would promise to come see Travion, but would rarely keep those appointments. I think there's evidence to support that she did not keep appointments. The state have a position with respect to the peremptory instruction on this language.
I would say that could go either way, especially with the rarely keep. That was testimony from Miss Love, but there was testimony down the line and in the CPS records that Dad would take her to see the child in the end of the CPS records, and that he had reestablished even during the school records that they saw each other. So my concern is with rarely. And so I would ask, Your Honor, if you're inclined to give it, to not give a peremptory instruction given the school records. Even I think Dr. Evans's reports said that they had reconnected, so that there was at least some connection.
Would often fail to keep those appointments.
We would be happy with that.
All right, I'd give a peremptory on that.
And with that change, you're going to do it peremptory?
Yes. Ronald Anthony was 23 while Travion was 20 years old at the time of the crime. I recall that evidence. I don't think there's any dispute to that. Mr. Waller?
I guess I just would have a relevancy issue as to, I think that's right. The age it's correct, but I think it's also trying to kind of go down the Ronald Anthony. Right. Right, and there's already a statutory mitigating factor as to his age. I just don't see where the relevancy of Ronald Anthony is coming in at this point.
Well, Your Honor mentioned earlier the issues about like leader or follower and sort of like the relationship between the two in terms of their culpability are relevant, and you sort of separated them out from the issues you were discussing with Mr. Brown earlier. And this is simply a statement of fact that goes to some of those circumstances.
All right, I think it's both. I think it's appropriate to give as a mitigating circumstance, and it is peremptory. I haven't done the math, but I'm assuming that there's no dispute that Mr. Anthony was 23 at the time of the crime. Yeah. Travion was kicked out of his father's house in April 2013. No objection.
Another one that was stipulated.
Right. Ronald Anthony arranged transportation after the murder.
It means rates of transportation for them to leave the scene after the murder. Ronald Anthony arranged for Maurice Brown to pick them up after the murder, if I'm getting that name right.
What's the state's position on this?
That's evidence.
Well, it is the evidence, but again, in this phase, there's a relevancy issue to me, but
It goes to the aspects suggesting leadership and everything else, which I think, although we're not asking for that specific mitigating, I think that's very different than the issue that we're talking about, which is sentence. I don't think anyone has ever said who is more culpable or not is not an issue for the jury to take into consideration.
Right. All right. I'll allow it, and it is uncontroverted, so it would be for the jury to give the appropriate weight to. So I think that's where it sits. But
Are you giving it as it is now? Ron mentioned some comments.
yes, I think it needs to be changed to arrange for Maurice Brown, whatever the gentleman's name was that picked him up, arrange for
Provide a ride.
right, to pick them up after the murder. What is the name? Is it Mark?
It's Maurice Brown.
yes, sir. It is actually DeAndre Maurice Brown, but he does go by Reese.
Okay. Maurice Brown after the murder. I'm sorry?
I just want to make sure I'm clear. When we argue, arrange for transportation, arranged for Maurice Brown.
Well, the way that I modified it is Ronald Anthony arranged transportation with DeAndre Maurice Brown after the murder. And the final is Travion has no prior convictions for violent felonies. There's no evidence of convictions for violent felonies. What's the state's position on this?
I guess I can certainly, just thinking out loud here, why aren't we going under the, I guess, the F1?
Answer to that is because we think that for our jurors, the fact that you have been to prison for possession of stolen property may very well be something that they consider to be a serious record. I mean, and so this is just a sort of a statement of what we think is a relevant fact and relevant for consideration in this case, but doesn't implicate trying to make a guess or a value judgment about what degree of criminal activity these 12 or 15 people would assess as being significant.
We want to make sure there wasn't an F1 issue here, because I know there are some procedures that have to be followed and we just want to make sure we're not trying to go down the F1 route if we're not going down that route.
Right.
We're not asking for
And we,
one route.
and we understand that, we just want to, so if we may have.
And the concern with that one is not only that, it's also there's evidence of breaking cause.
And other things that could be considered, but there was no evidence of him doing any violent felonies, or certainly no convictions of violent felonies in his record. His conviction came out from the probation officer. From the state's question.
Sensitive area, we're good with it as it's written.
I think the way that it's worded is, it should be given as a mitigating circumstance, and that would be a peremptory instruction. All right. All right, now let's turn, you have, in addition to the mitigating or the mitigating circumstances that you've requested, you have some other language.
Yes, sir. We have that, we have some language stuff. We have also a motion concerning prosecutorial argument.
All right.
And
So let's look first at the request for residual mitigating circumstances.
And I'll let this
self.
We would ask that you just follow the pattern jury instruction on this. I think it's sufficiently covered by, I guess, 10.
Right, I'm inclined to stick with the pattern instruction on this and give, as is in the draft before you, labeled as number 10, just give the language that I've given. All right, the next instruction that I have in my stack is a request for a jury instruction on sympathy and mercy.
we just stand by what the motion says.
What's the state's position on this?
Judge, the case law is clear that the state needs to argue that the court cannot use sympathy and mercy, and the jury, excuse me, should not use sympathy and mercy. So to ask for an instruction to the contrary, I would say is against settled law, and I would ask that you deny that one. Specifically citing State versus Cummings 361, NC 438, State versus Price 326, NC 56, and State versus Artist 325, NC 278, all of which talk about it's proper for the jury, for the argument to be made by the prosecutor that the jury should decide this case on the facts and not use sympathy and mercy. So to ask for that would be contrary to law.
All right, what's the first cite that you had?
The first one, Judge, and it's page 128 on our books, but it's State versus Cummings.
All right, I can go from there.
Sure.
All right, I'm going to decline to give this requested instruction. I'm going to decline to give this requested instruction. The next is a request for jury instruction on connection between mitigating circumstances and the capital crime.
And this one, Your Honor, I think that the pattern jury instruction were most updated and all without taking into account the Supreme Court's decision in Tenard v. Drecke. I know we mentioned that some during jury selection. I think it's a adequate statement of the law. I think it's one that otherwise the jury may not realize, and I think it's a short, adequate statement, a quick statement of the law that I think would give the jury a more adequate understanding of mitigating circumstances in the case.
And what's the state's position?
This was pattern jury instruction would sufficiently cover this issue as well.
The instructions we gave to the jury and the instructions that they said were that they understood they had to consider each and every one that Your Honor gives them. And so in whatever form, whether it's a peremptory or whether it's a list of things, they have been told, and you will tell them that they have to consider those. So I would submit that this does not assist in any regard.
And what I was looking for is under your issue 2, the definition of a mitigating circumstance, and I think the pattern jury instructions explain what the purpose of a mitigating circumstance is.
Right. I think the language of the pattern instruction is, however, in considering issue 2, it would be your duty to consider as a mitigating circumstance any aspect of the defendant's character or record and any of the circumstances of this murder that the defendant contends as a basis for sentence less than death, and any other circumstance arising from the evidence that you deem to have mitigating value. I think that adequately instructs the jury on the law relating to the nexus between a mitigating circumstance and the crime itself, or the lack of the need for such a nexus. So I would decline to give this instruction.
similarly tracking the jury instruction for the E9, which, for the record, we are objecting to submitting, but it does have language there that we would submit as appropriate because it says that this defendant's conduct has to be especially heinous, atrocious, and cruel, since we would argue, and I think we have decided to give the Tyson Edmonds instruction, that there is, at least there's arguments, and it's unclear even from the jury's findings, that he was the one who would have done the heinous, atrocious, and cruel acts that they're maintaining, and that they should have to find his conduct to be, because that's what we're concentrating on, is the conduct of the defendant.
What's the state's position on that?
We've already agreed to an expansive definition of the Edmonds-Tyson issue in 1A, and there is support in the case law that the jury can find he was a substantial participant in the underlying felony and not have to actually lay the blows. That's one of the prongs here. This is adding an additional element that the state needs to prove, and I would submit it's certainly improper, especially in light of the fact that we have agreed that they have to get past that first issue to move down your instructions, and so I would ask that you deny it.
Right.
And I would just point out that the jury could find against us in the Tyson Edmonds issue for various reasons, but not believe that his conduct was the one that was especially heinous, atrocious, and cruel. So there's a difference with it and all, and that's why I think this instruction is necessary, because I do think Eighth Amendment jurisprudence is arguing on the mindset, the activity of the person charged. So I think that just because they would get past issue 1A does not necessarily mean that they are not acting with that they could not find that his conduct was not especially heinous, atrocious, and cruel, even though it meets all the criteria of under Tyson Edmonds to proceed forward.
I am satisfied with the wording of the aggravating factor E9 as in the statute, namely that the capital felony was especially heinous, atrocious, or cruel. So I'm going to decline to or I guess it's was this murder especially heinous, atrocious, and cruel. And I'm satisfied that the explanation given in the pattern instruction is sufficient.
For the record, you would know
Exceptions, they don't believe I put this otherwise on it, under the 5th, 6th, 8th, and 14th amendments, and then under 15A 2000, and the North Carolina Constitution.
The next is request for jury instruction under Edmonds and Tyson.
I want to point out, if it's not clear in the motion, that we are only asking, this is only a suggestion of one additional paragraph of it. Otherwise, we are accepting the pattern instruction. The basis of this particular argument is that since they made the decisions based on acting in concert, was how they were instructed in P&D murder, just to put clarity with this additional paragraph, that's not the theory they are to consider now.
What's the state's position?
Judge, again, we've conceded the Edmonds-Tyson issue, which the law, as it is, does not require, and there's no part of it, him or acting with others. And so I would submit that, again, once they get through issue 1A, or if they get through issue 1A, this issue will be satisfied. And so, again, we have conceded, given your concerns about the theories of the case, but if they make it past 1A, we shouldn't be required to prove yet another element.
I'm satisfied with the pattern Edmonds-Tyson instruction that the defendant himself, A, B, C, or D. I think that is a clear statement of the law.
no objection for the 8th, 5th, 6th, 8th, 14th.
So no. So noted.
The next one, motion.
To instruct on burden of proof mitigating circumstances, we don't wish to be heard any further than what the motion says.
All right. Pattern instructions adequately instruct the jury on the law, and I'm going to decline to give this expanded language. And this would be with respect to the motion on defendant's burden on mitigating circumstances. And I'll note your objection for the record. Motion to restrict prosecutor's argument.
This is a motion going to various, and I will say this is not based on anything with these particular prosecutors. It is based on problems that have been largely discussed by the North Carolina Supreme Court in cases throughout the state about certain arguments that have been done in the past that are inappropriate, and that we are listing out concerns here about it. So I think we listed numerous ones. I don't know if there's any ones the state feels are inappropriate with it or not. I'll be glad to address those, although most of them I think are pretty. I know there's some that may not be supported by the case law, but most of them I think are pretty well supported by the case law here.
All right. Well, many of these are fairly well settled in the law, and I wouldn't anticipate that the state would be making arguments based on some of these. Are there any that the state particularly wants to be heard on or have clarified?
Not at this time. I would just ask that this be a matter held, during the course of arguments, that everybody understands that they can object, and we understand the bounds of the law and fully intend to stay within the bounds of the law. So, I mean, these are very general in nature, so if there's something specific here that Mr. Brown or the court is concerned about, then we can address that, but otherwise I would just ask that it be held in, addressed as these issues come up, if they come up.
Right. What I would say is that if you want clarification prior to your argument on whether anything that you intend to say would violate any of these, you could bring that to my attention prior to the closing arguments. But I think that this one is probably best left until the morning of the closing arguments, once you've refined exactly what it is you want to say, and if you feel that you need to be heard on any of these issues, that's probably what we'll do.
Yes, sir.
All right. There's an objection to E5.
Which I think if anything's in there that's not included in my previous.
Objections to E5, I would just like to include this as part of my objections to E5 and don't want to be heard any further.
Right. Right, and I think I've addressed all the issues relating to E5 that I'll permit E5 to be given with respect to armed robbery.
And the next one is, I think, the
Objections to E9, again, if there's anything that I did not state in my previous objections, although I think I did make these same points, we'd just be reiterating this is part of our basis for the E9 objection, which I understand the court has ruled on.
Right, I've already ruled on that, so. Then we have request for jury instruction on personal viewpoints.
I don't want, just want to stand by what we wrote in the motion. Don't want to wish to be heard further.
What's the state's position on that?
We object. I think it's, I'm sorry. We would object. I think this covers issues that were clearly covered in jury voir dire, and the pattern instructions cover the issues that this motion would be concerned with.
All right, I believe the instructions are clear on the duty of individual jurors to reach this decision, and so I'll just simply rely upon the pattern instructions in this regard, and will decline to give this request instruction on personal viewpoints. We'll note your objections. The next one is a request for jury instruction, failure of jury to reach a unanimous verdict. State wish to be heard.
It's just contrary to law, so I'd ask that you deny it.
I'm going to, I believe that the instructions clearly instruct the jury with respect to their duty and the law relating to unanimity, so I'm going to stick with the pattern instructions on this, decline to give this requested instruction. Residual doubt.
Stand by what we voted in the motion.
State wish to be heard.
Residual doubt, is that where we are?
Yes.
Again, that is contrary to settled law, State versus Fletcher, 354 NC 455.
And I agree. I'm going to decline to give this instruction. And the instruction on mitigating circumstances is adequate to instruct the jury on the law relating to what they should consider. All right, so I believe that was the last of the requested instructions. So it looks like where we are is I'll receive a few modifications. Only one, so number 11. All right. And I will take these. You've emailed this document to the clerk?
Has kindly emailed that
Right.
document to the clerk.
I will have the clerk forward this document to me, and I will incorporate this into both the instructions and the verdict sheet, hopefully with the changes I made. And at some point over the weekend, I will send you a draft of the jury instructions based on what we've talked about today. So the only thing, as I recall, the only thing that I'll expect to receive is the slightly modified instruction that the defense wishes to give as a mitigating circumstance on mental health illness. And we've talked about what that might look like, and I'll leave that up to you to refine. And so I'll receive that, I'll incorporate that in to the draft instructions that I'll send out, and then, but with the understanding that we'll talk about all of that on the record once we get back together. Yes.
Oh, I was going to say, I think one thing, I think it's understanding with the court and all the parties, but I guess we've never actually said on the record here that 1A will be given. So I just...
Yes.
The Tyson Evans issue.
Right, yes, that's in the draft that I gave you. That would be the language that I would intend to give is issue 1A as it's written.
Yes.
On page 4 of the draft I gave you, so that would certainly be included.
In my understanding, I just wanted to make sure that wasn't sure the record
Right.
was clear, because we didn't talk about specifically, so just putting it out.
Right, and then again for the record, well, it goes without saying I'm using pattern jury instruction 150.10, and then so it does include issue 1A, then issues 1 through 4, don't believe there were any other options that I needed to bring to your attention, but those would be the ones I'll bring to your attention for the record purposes. All right, so we'll prepare all of that. I'll send draft instructions, draft verdict sheet or recommendation sheet to you over the weekend. We'll resume a charge conference at 9:30 Monday morning. We've already talked about the order of the closings, that the state will have the first closing arguments, and one or both of you may address the jury, and then the defense will have final closing argument. One or both of you may address the jury, and it would be helpful if you'd let me know, just so I know who to call on when we get to that point. All right. Anything else that we need to take up? All right. Very good. Thank you. We'll be in recess till 9:30 Monday morning.